The law states that parents have a constitutional right to raise and educate their children, but the states also have the right to ensure that children receive an education. At times, the goals of parents may differ from the goals of the states and vice versa. When this happens, litigation often ensues. The Family Educational Rights and Privacy Act of 1974, FERPA, was enacted to avoid inaccurate categorization and/or stigmatization of students. Information in student records was being released to organizations outside the educational institution, when parents did not even have access to the records. With FERPA in place, student records are kept confidential and the student right to privacy is protected. FERPA also means that schools have established procedures for a parent to request to review the student records. It is recommended that parents not be left alone with records so that guidance can be provided to avoid misinterpretation by the parent. Schools should maintain a log with the name of the record reviewer and the reason for review. Only an individual with legitimate educational interest should have access to student records. People such as teachers and guidance counselors qualify as these individuals. All access to records is to ensure the best possible education for the student. Directory information, such as name, address, telephone listing, date and place of birth, major field of study, etc., are not protected by FERPA. Information that may be released should be sent in a notice to parents, possibly in a letter or student handbook. A FERPA case, Owasso Independent School District v. Falvo, involved a mother of 3 middle school children that claimed student grading and reading scores out to the teacher violated FERPA. One of the main questions was, when does something in the classroom become an educational record? The district court held that grades put on papers by another student are not education records. The 10th Circuit reversed the district decision, finding that grades marked by students on each other's works are education records. So the very act of grading violates the privacy of a student by releasing the grade to another student. The 9-0 decision by the Supreme Court decided that peer grading does not violate FERPA. Due to teacher time constraints, grading of individual assignments is not protected before the grades are entered in the teacher gradebook. The gradebook being the actual beginning of an educational record. Grades are not to be hung on doors, even using the Social Security number as a code, and students are not to know the course grades of other students. Class grades are protected under FERPA. Parents can choose an alternative to public school for their children. Some choices are charters, private schools, or homeschooling. The 10th Amendment states that public schools are run by the state, and as arms of the state, they must abide by the U.S. Constitution and federal laws. There are few cases about charter schools because they are so new. Private schools that do not get federal funding still must abide by laws, but do not have to abide by the Constitution because they are not arms of the state. Homeschooling regulations vary by state. Some homeschool regulations are strict, while other states have lenient regulations. Pierce v. Society of Sisters from 1925 is a case that tested the bounds of alternative schooling. In this case, a private school, the Society of Sisters, and a military academy, argued that the Compulsory Education Act was reducing their enrollments and therefore their profits. These institutions maintained educational institutions, but after the Compulsory Education Act, parents were becoming more likely to send their children to the public schools. The decision in this case allowed parents the right to choose the type of school for their children. The court affirmed compulsory education for children, but allowed alternative choices to the public schools. This case was one that sought to balance the rights of parents to raise their children and the state's interest in ensuring that all children receive an appropriate education. The Compulsory Education Act of 1922 made education mandatory for children aged 6 to 18. This act was involved in the Wisconsin v. Yoder case in 1972. In Wisconsin v. Yoder, an Amish family refused to send their child to the public high school and was fined for not adhering to the Compulsory Education Act. Amish families send their children to school up to the 8th grade to obtain basic skills. They feel that the public high school environment, public or private, runs contrary to the Amish religion and way of life. The Supreme Court affirmed the reversal held by the Wisconsin Supreme Court. This decision held that Amish children do not have to attend school past the 8th grade. The Wisconsin v. Yoder case created a slim exception to the compulsory education laws for a few reasons. The court's reasons were that Amish children receive vocational training from their family and community after 8th grade. The Amish community has successfully survived for more than 300 years, and the freedom of religion and the entitlement to exercise that right. This case is the only exception the courts have allowed to compulsory education. Schools put into place policies and procedures regarding compulsory education and homeschooling. Parents can choose between public school, charter schools, private schools, and homeschooling for their children. A balance between school goals and parent goals can be better struck when there are clear lines of communication between parents and schools.